What is this video about? Let me explain you by means of two examples. First case. Miss Watts traveled to France for a hip operation which could be provided sooner than in the United Kingdom. When she returned, her claim for reimbursement for her medical expenses was refused. Second case. A German producer of unpackaged chewing gum wants to import his products to Austria. However, in Austria only packaged chewing gum may be sold from vending machines. That is why he is not allowed to sell his products in Austria. These are two completely different cases, and an almost unlimited number of other examples could be added. How can those cases be solved? And how are those people connected to this topic? This video should help you in solving those cases in the context of the so-called fundamental freedoms, and you will see surfing through such a case is not rocket science. Together we will go through the different parts of this checklist step by step. Here we go. First of all, we have to see if either the general fundamental freedoms apply or whether there is a more special provision for the case you want to solve. Well, you might know where to find the fundamental freedoms in the TFEU, the Treaty on the Functioning of the European Union. But where can you get to know if such a special provision exists? I will show you how to find out. Go to the webpage of the European Union at europa.eu. Then select one of the 23 official languages. There is plenty of useful information, but as we want to find out whether there is a special provision for a certain case, we will click on Legislation and Treaties. EULEX provides free access to European Union law and other documents considered to be public. Click on Most recent legislative documents available on EULEX. Here you can find the TFEU, including the fundamental freedoms, which you have seen before. But in order to find out if there is such a special provision, click on Legislation in Force. Then click on the Directory button. This analytical structure of the Directory of European Union legislation includes 20 chapters with divisions into further subsections as necessary. In brackets, you can see how many documents are contained in those chapters and subsections. So let's say we want to know if there is a special provision on the rights of EU citizens to move and reside freely within the territory of the EU. Click on Chapter 5. And then on subsection 10. If you now search for citizen, then you will find Directive 2004/38 on the right of citizens of the Union and their family members to move and reside freely within the territory of the member states. So let's get back to our checklist. If you have found such a special provision, you have to read through it and find out whether it applies for your case. In this situation, you will solve your case according to the special provision of EU law. If no such special provision exists, or if it does exist but it does not apply for your case, then we continue with the checklist. Next, we have to see whether the relevant definition has been fulfilled. As you can see, there are some freedoms related to persons and one, the free movement of goods, related to products. Depending on the different fundamental freedoms, we have to check if the relevant definition is fulfilled. So, for example, for goods, all products which can be valued in money and which are capable of forming the subject of commercial transactions. Or for workers, anyone who for a certain period of time performs services for and under the direction of another person in return for which he receives remuneration. The same is true for services and establishment. Then we have to see who can rely on the fundamental freedom. First of all EU citizens, meaning persons holding a passport of one of the member states, can rely on EU law. The same is true for third country nationals who are family members of an EU citizen. Last but not least, also third country nationals who cannot derive certain rights from family members can rely on EU law under certain conditions. You are from a third country and want to find out for your case, I'll show you how. Once again, we'll go to the web page of the EU, select the language, and you have to know that there are two databases to find out, and I will show you one way. Click on Institutions and Bodies, as one of these databases is run by the Council of the EU. Click on Council of the EU, and then scroll down to access the web page of the Council. Then click on Policies, Agreements, and search the Agreements database. Most likely the easiest way will be to click on Select a party from the list of parties. If you then click on T for Tunisia, you will then get a list of all the agreements which have been concluded by the EU and this country. So, for example, a Tunisian citizen can try to derive certain rights by relying, for example, on the Euro-Mediterranean Agreement establishing an association between the European communities and their member states on the one side and the Republic of Tunisia on the other side. So now you know, and therefore let's get back to our checklist. Next we have to find out whether our case has a cross-border aspect. This part of the checklist is very easy. We just need a case which involves two member states of the EU, so for example as in the case of Ms. Watts. Remember, as she could not get medical treatment in due time, she went to France to get a hip operation there. As this case involves two member states of the EU, the United Kingdom and France, Ms. Watts can rely on EU law, the freedom to receive services, in order to get reimbursement of her medical costs which she had to pay in France. This would not have been the case if she had stayed in the UK, meaning only involving one member state of the EU. The next part of the checklist is basically only valid for the free movement of workers. Before I give you the details, let me tell you more about the reason why. When the new member states joined the EU in 2004 and 2007, the so-called old member states feared an invasion of cheap workforce from those Eastern European countries. This photo of a Polish plumber can be used to personify this often used picture of craftsmen from Eastern European countries coming to the EU. Although this man doesn't look that frightening, and actually he has been used to counter negative Western rhetoric about Eastern European workers. This is the system which the old member states have invented in order to keep people like this Polish plumber from their labor markets. During those 7 years from the day of accession, the old member states can, they don't have to, keep citizens from those new member states from their labor market. Even though a worker from a new member state can basically rely on EU law, he cannot do so during this transitional period. The delimitation of fundamental freedoms. Think about buying lottery tickets. Which fundamental freedom could apply? Well, on the one side, the lottery ticket printed on paper would fulfill the definition of a product. On the other side, getting the chance to win a lot of money also constitutes a service in the sense of the case law of the European Court of Justice. How do you know which fundamental freedom to apply? The solution is very simple. Once again, we are not talking about rocket science. So just think of the one which is more important to you. Well, I guess this would be the chance of winning money, not the piece of paper. or in general terms, you have to find out which fundamental freedom is more important and which is entirely secondary in relation to the other and maybe attached to it. The public service exception. As we have seen, the definition of a worker is as wide as possible. Consequently, also civil servants fall under this definition. Therefore, citizens from another member state could apply for such a job, even in certain sensitive areas. At this stage, the public service exception comes in. It exempts this sensitive field from the scope of the fundamental freedoms. Therefore, certain sensitive jobs can be reserved for nationals only. In the course manual, you can find some examples of such sensitive areas. Now, who is bound by the fundamental freedoms? Or, in other terms, what is the national measure in this case? From the perspective of the citizen trying to benefit from the single European market, this will most likely be the member state trying to protect its national market from goods, services, workers, and so on from other member states. Coming back to our preliminary examples. For example, the refusal of the British authorities to reimburse the medical costs of Miss Watt's surgery in France, or the Austrian law not allowing to sell unpackaged chewing gum from vending machines would be qualified as the national measure in these cases. So what falls under the term of a member state? To make a long story short, this term is understood in a very broad sense. From a horizontal perspective, talking about Montesquieu's separation of powers into the legislative, the executive, and the judiciary power, not only legal provisions, but also court and administrative decisions can be challenged in the light of the fundamental freedoms. From a vertical perspective, not only the federal and the local level, but even municipalities are bound by the fundamental freedoms. It should be noted very briefly that member states also can infringe the fundamental freedoms when not acting, by omission, and when they use an apparent private company on which they have a certain influence. But not only the member states which have signed the treaty which established the fundamental freedoms are bound by them. According to a very pragmatic approach of the European Court of Justice, the ECJ, it does not make any difference from the perspective of Mr. Bosman, a professional football player who is a worker in the sense of EU law, if he is not allowed to play football in another member state because of law or because of a regulation of an international football association. Therefore, also sports federations are bound by the fundamental freedoms. Last but not least, private persons are generally not bound by the fundamental freedoms. Only in the field of the free movement of workers has the ECJ decided that also private persons, for example a company requiring a discriminatory language certificate, are also bound by the fundamental freedoms. In which way does this national measure constitute an obstacle to the fundamental freedoms? The next part of the checklist is not that relevant in practice, as rarely any case is sorted out at this stage. According to the Dassonville case of the ECJ, this includes all trading rules enacted by member states which are capable of hindering, directly or indirectly, actually or potentially, trade between the member states. As you can see, this is once again a very broad definition.